Hi everyone, grab a drink and settle in. This is the Wheels and Spills podcast, where we sip cocktails and unpack the most fascinating estate disputes behind the court judgments. The podcast is about real people, real family disputes, and the wheels that spark them. Now, to help me spill the story behind our case, I have Tim Staindl. Tim is a barrister who has particular expertise in equity, trusts and probate. So Tim, what case are we unpacking today?
So today we're looking at the recent decision from the Supreme Court of Appeal in the estate of Brummer, Sternfein and Bloom, the names of the parties. The dispute takes place in the context of an application by a man named Ilan Sternfein, and he was bringing an application seeking further provision out of the estate of Maurice Brummer, pursuant to Victoria's Testator's Family Maintenance provisions. The defendants are the executors of the deceased's will and estate, and they brought an application to summarily dismiss Mr. Sternfein's application, saying that he wasn't an eligible person because he was a former stepchild of the deceased. And it's interesting because the case went all the way through the Supreme Court. There was a judicial registrar's decision first, then there was a trial judge's decision, and then there was a Court of Appeal decision which overruled that.
Okay, look, there's a bit to unpack here, but before I do that, I want to provide a brief summary of the background to our viewers. And this is taken from Ilan's affidavit. So Ilan's father died when he was just 10 years old. A couple of years later, Ilan's mother formed a relationship with Maurice Brummer, the deceased. Now, at the time, Ilan was 12 years old. Ilan lived with the deceased for 7 years until he was about 19 years old, and then he moved into a shared house. Shortly thereafter, the relationship between the deceased and Ilan's mother ended. So Ilan had no contact with the deceased until 2013. By then, Ilan was 35 years old. Now, Ilan had been living in Canberra for some years when the deceased reconnected with him through Facebook. Ilan says that when they reconnected, the deceased and him established a solid relationship. He took his 2 children to visit the deceased in Melbourne when they were aged 6 and 8. Ilan says that the deceased adored his children and even asked him to refer to them as the unofficial godfather. He also claimed that the deceased referred to him as his son. Now, Ilan remained in weekly contact with the deceased by telephone and via Facebook until he died in July 22 at the age of 78. The deceased was survived by his 2 biological children. In his will, though, he made no provision for his biological children or Ilan. He left his entire estate, which is valued about $2.6 million, to charity. So then Ilan commenced proceedings in the Supreme Court of Victoria seeking further provision from the deceased estate. Now, Tim, we know that in order to bring a claim, he must be an eligible person. The executors of the deceased estate, as you said, argued that he was not eligible. Now, he wasn't the biological child of the deceased, nor was he a stepchild. So therefore, they sought to have Ilan's case summarily dismissed. Can you explain to our listeners what this actually means and what were the executors trying to achieve?
So they were trying to summarily dismiss Ilan's claim, and that's a legal wording for them trying to put a halt to it, to end the proceeding before it even reached a trial. So under the Civil Procedure Act, a court has the power to throw out a claim if it has no real prospect of success. The legal standard is whether a claim is fanciful as opposed to real. So if a judge looks at the evidence and the nature of the claim and decides that with what's before them, there's simply no way that the person can win based on the law, then they can dismiss the claim at that early stage in order to save everyone time and money.
Yeah, okay. So in the first instance, the judicial register refused to summarily dismiss Ilan's claim. So then the executors appealed to the trial division of the Supreme Court. The judge in the trial division allowed the executors appeal and summarily dismissed Ilan's claim. So then Ilan seeks leave to appeal that. So we're here now to discuss the Supreme Court of Appeal's decision. So the application to appeal turns to a discrete point. Is Ilan an eligible person, and whether he has a real prospect of establishing that he's eligible to bring a claim? Now, Tim, you and I, we do these claims all the time. And there are people who clearly fall into the definition, and then there are others who may be on the borderline. Can you take us through who's eligible to bring these claims and what did the court consider?
So since legislative amendments that came into effect in 2015, only certain people are deemed to be eligible persons under the Act. And the most common amongst those, the ones that we see all the time, are spouses, so married or de factos, and children of the deceased, and they can be adult or minor children. Stepchildren are also eligible, so they're being the children of the deceased spouse or domestic partner at the time that the deceased died. But then what about former stepchildren? So a child of someone who was a spouse or domestic partner of the deceased, but there was a separation before death.
Yeah. Can we just also stop there? So in terms of stepchildren, the reason why he doesn't fall under stepchild is because the relationship ceased. So his mum and the deceased broke up. They had a settlement, so he's no longer the stepchild.
That's right. And former stepchildren aren't expressly included in the legislation as eligible people. But the Act does have one other limb of eligibility, which says that if you, for a substantial period during the life of the deceased, if you believed that the deceased was your parent and you were treated as a natural child of the deceased, then you're an eligible person. And Mr. Sternfein, Ilan, was saying to the court that as a former stepchild, he fitted into that category.
Yeah. So Ilan basically was claiming he's eligible because he believed the deceased was a parent. The deceased treated him as a natural child for a substantial period of the deceased's life. So there's really three limbs to this, and I want to expand on each of these. Firstly, the belief that the deceased was a parent. Tim, how did the Court of Appeal interpret this, and what evidence did Ilan have to establish this?
So the critical point here is that the Act defines a parent to mean everything that we think a parent means, but it also includes any person who had day-to-day care and control of the child and with whom the child was ordinarily resident. So all Ilan, the plaintiff, had to do was convince the court that it wasn't fanciful, that he would be able to ultimately convince the court at trial that he believed that the deceased had day-to-day care and control of him and that he lived with him. And given that Ilan had lived with the deceased for around 7 years, during which time the deceased was his stepfather, that wasn't really a point in contention. So that one of the three limbs was satisfied.
Okay, so now secondly, I want to look at treated as a natural child. Did the deceased treat Ilan as a natural child? Now, to answer this question, the Court of Appeal noted that treatment can be shown by looking at the deceased's conduct and behaviour towards Ilan. Can you give us some examples of this?
Yeah, so this was the critical point, and it's the point on which the Court of Appeal differed from the trial judge. And the question was, well, what does it mean to treat someone as a natural child? And it's very difficult to say, as we know. Parents treat children, natural children, stepchildren, foster children, just as examples. They treat them in varying ways. And there's no unifying concept of what it is to have a parent-child relationship, let alone a natural parent-child relationship. And so for that reason, the trial judge said that given the impossibility of identifying behaviours and actions which are specific to the treatment of natural children in particular, as distinct from children generally, then the words need to be given some other meaning. And so the trial judge said that treated as a natural child really meant regarded as a natural child. And so the trial judge found that there had to be an actual belief on the part of someone that Ilan was a natural child of the deceased. And no one was of that belief. So that's why he failed before the trial judge. The Court of Appeal viewed it differently. They said that the court's often required to make this sort of determination without any objective criteria. And it gave a couple of other examples of that sort of reasoning. And it said that the meaning of the word treat just means treat. And Ilan's evidence that he had been treated as a natural child included, for example, that the deceased had been involved in his extracurricular activities, that he'd disciplined him as a child, that he'd played an important role at his bar mitzvah. So for the Court of Appeal, it wasn't fanciful that at trial, Ilan would be able to convince the court that he was treated as a natural child.
So Ilan really didn't need to show that the deceased treated him identical to his biological children. It was really the treatment was of the character of what they would treat a child.
That's right. And the Court of Appeal said that a point of comparison might be how he treated his biological children, but that wasn't determinative. Ultimately, you just look at the relationship and taking all the facts into consideration, make a determination as to whether the deceased treated Ilan as his natural child.
I want to move on to the third limb, I would say. There must be a substantial period. So in this case, Ilan lived with the deceased for 7 years, since he was 12 years old until he was 19 years old. Did the court consider that to be a substantial period?
So again, this was just a summary dismissal application. So all the Court of Appeal and indeed the prior judicial officers had to determine was it fanciful that ultimately Ilan would be able to convince the court that he had lived with the deceased for a substantial period. And the Court of Appeal said, no, that's not fanciful. We think it's well within the realms of possibility that he will be able to convince the judge at trial that he lived with the deceased for a substantial period, being those 7 years.
Do you think it also assisted Ilan in the fact that he reconnected with the deceased later in life and then that relationship continued?
I think it's really important because there is a possibility that this Court of Appeal decision will create a real bump in the number of cases. Former stepchildren coming forward now knowing that there's Court of Appeal authority to the effect that they can be eligible people. But ultimately, the question in the substantive proceeding when you get to trial is you have to satisfy the court that the deceased had a moral obligation to provide for you. And that's where that evidence from Mr. Sternfein or Ilan will be really important, is to convince the court or satisfy the court that he did have a moral obligation to provide for him because he had an ongoing relationship with him even at the time that he died.
I think the inference, though, substantial doesn't have to be the majority of the deceased's life. I mean, he was with the deceased for 70 years, so I think that's an interesting point to make.
I think that's right, yeah.
Really, in summary, the Court of Appeal had determined whether Ilan had a strong enough case to go to trial on the basis that he was treated as a natural child of the deceased. Now, the Court of Appeal held there was sufficient evidence capable of supporting a trial, and the appeal was allowed and the summary dismissal was set aside. So the Court of Appeal really affirmed that a former stepchild who had a meaningful parent-child relationship with a deceased person could qualify as an eligible person. Tim, what are your final thoughts or takeaway from this case?
Like I said earlier, I think there's a real possibility that this will open up a whole nother category of applicants in testator's family maintenance proceedings. I think that's a real possibility because for many years there had been uncertainty as to whether former stepchildren were eligible persons. Now we've got Court of Appeal authority saying that they are, but ultimately at the end of the day, everything's going to turn on its own facts, and the real question that has to be determined at trial or as agreed between the parties is, did they have a relationship of the nature that gives rise to a moral obligation on the deceased to provide for them in their will?
Yeah, and it can be harsh, isn't it? We've seen these cases where just because his mother's relationship ended with the deceased, he still saw him as a father figure and wanted to continue that relationship.
That's right. Behind all the interesting law, it's quite a sweet story.
Yeah. Well, thanks, Tim. And that's today's spill. So thanks for sipping along with us on Wilson Spills. Join us next time for another cocktail, another case, and another story worth unpacking. Cheers, Tim.
Cheers.